Hello, I am G. Riley Hetherington of the Hetherington Law Firm. I want to visit with you today about the probate of a Texas will in the state of Texas and the steps needed to be able to accomplish that result. First of all, let's talk about what a will is. A will is a document that is signed by the person during their lifetime before they pass away that does normally several things. It disposes and names persons, charities, etc. as beneficiaries of the amount of those assets and who will receive what upon the death of the person. Typically, it appoints a person to administer those assets after the death of the person. And finally, it confirms that this is the last will and testament of the person and that the person has the qualifications and ability to be able to sign that document. In Texas, there's two types of wills. There is what is called a holographic will, which is a will that is wholly in the handwriting of the person who passes away and is signed during that person's lifetime. And then there is a non-holographic will, which is a will that is typically not in the handwriting of the person who passes away, but is signed during that person's lifetime. Typically it is typewritten. Typically it is signed by that person and requires two witnesses to also witness the fact that the person signed the document on the date that's stated in the will. So what is the probate of a will? What does that mean in Texas? Well, Texas is governed by the Texas Estates Code and has set up probate courts in the various 254 counties of the state of Texas. Those courts take jurisdiction over what is called probating the last will and testament of the person who passes away, be it a holographic will or a non-holographic will. And that process does a couple of things. It confirms legally that this is the last will and testament of the person who passed away, and will serve as the document as far as disposition and administration of any of the assets. And it also confirms that all legal requisites have been met with respect to the execution of the will. So how do you begin the process? The process is started with what is called an application for probate, which is a written document where you present to the probate court the will as well as the information necessary for the court to confirm that this is the last will and testament of the person, as well as the fact that all legal requisites have been met. All of the applications in Texas, regardless of which county you're in, are filed electronically. And so that process must be followed. Once that document is filed, a case number is assigned by the particular probate court that you're in. Well, which county do you file in? The county where the person passes away is the primary county where the will application will be filed. What happens once this application gets filed? If it's appropriate and notice is filed and the documentation is completed by the probate court clerk, a hearing is set by the probate court. Typically that is an uncontested hearing, and at that hearing you have to present the will, you have to present the two witness testimony, as well as the information that the person has passed away, that this is the last will and testament. And the court also requires that all of that application process be started no less than 4 years after the person passes away. You'll also hear the terms, what is called whether the will is self-proved or not self-proved. You can also look at the wills and see sometimes that a notary has signed after the two witnesses and person has signed the will. Well, a self-proven will is simply a will that has been executed with appropriate formalities and avoids the necessity of having to bring live witnesses that witness the will to the court. A non-self-proven will, you do have to produce those witnesses. So once you and your counsel look at the document, it can be determined whether it's a self-proven or a non-self-proven will. Now, there's one final thing that you need to know. The will normally appoints someone to act as a representative to administer the estate that has been created upon the death of a person, which consists of the assets of that individual during and acquired during lifetime, as well as the disposition of those assets after death, as well as a person that will have to deal with any debts that exist at the time of the person's death or any taxes that have to get paid. That administrator is typically in a typewritten will that is prepared typically again by a lawyer as an independent executor and acts independent of court control. So that's a very important job, and it's one that the court will take actions in connection with the administration and guide that person through. An administration of a estate is necessary if there are debts and liabilities that have not been satisfied at the time of the person's death. However, there's a procedure in Texas that's also known as a muniment of title, where you simply offer the will, and that will is a muniment of title which passes title of the assets to any person listed in the will. The muniment of title proceeding does not require an administrator to be appointed, but does transfer title to those assets. The important difference, however, is there cannot be the necessity for an administration or handling of the assets after the person dies by a particular representative. What do you need to do when you want to have a will probated and file the application I just discussed? And what documents do you need to bring to the meeting with us to be able to start that process? Well, again, the law firm will be more than happy to send you information sheets for you to be able to fill out. You do need to bring with you the original will at the time that you have a meeting with us and that we get started on that matter, because that must be filed at the time that the application is presented to the court. So, a lot of information in a short amount of time. Please feel free to get in touch with us. We'll be more than happy to take you back through those steps and describe in more detail what will be needed. But it's very important that the time limits of 4 years be observed and that you take action so that those assets can be transferred to the persons that are listed in that will. Thank you very much.